Doing so violates fundamental constitutional protections and case law precedents. The 5th and 14th Amendments guarantee due process, meaning no person shall be deprived of life, liberty, or property without fair legal procedures, while the 6th Amendment secures the right to confront witnesses and to have compulsory process for obtaining witnesses in your favor. The Supreme Court reaffirmed this in Washington versus Texas in 1967 by ruling that defendants have the constitutional right to call witnesses in their defense. The state, being an artificial legal entity, cannot testify as a witness with first-hand knowledge of alleged facts because testimony must come from competent witnesses subject to cross-examination as required by Crawford versus Washington in 2004, where the court held that testimonial evidence is inadmissible unless the witness is available for confrontation. Furthermore, in Berger versus United States in 1935, the court emphasized that the government's role is not to win at all costs, but to ensure that justice is done. If the state acts as both prosecutor and witness, it compromises neutrality and fairness, violating due process under Brady versus Maryland in 1963, which requires disclosure of evidence favorable to the accused. Article 3, Section 2 of the Constitution requires actual cases or controversies with real parties in interest, and under the rules of evidence, statements by lawyers or prosecutors are not evidence unless supported by admissible testimony or exhibits. The 14th Amendment Equal Protection Clause further guarantees that all defendants are entitled to a fair trial without the imbalance of the state serving as both judge and participant. In short, constitutional law and Supreme Court rulings affirm that the state cannot be both the plaintiff and the witness because justice requires impartiality, confrontation rights, and a separation between the accuser and the